Everybody to today's LCH lunchtime Zoom session, which is an author meets critics panel on Stephanie DeGooyer's book, Before Borders, A Legal and Literary History of Naturalization, published by Hopkins at the end of 2022. So we have two speakers today, and then Stephanie will respond to the commentators. Katarina O'Brien at the University of York and Nicole Wright at University of Colorado at Boulder. So I'll introduce each speaker when they're about to speak, and then I'll introduce Stephanie, and we'll run for about 90 minutes altogether. So thanks to everyone for coming. Thanks to our commentators for agreeing to commentate. And I should also mention the next session upcoming is on Wednesday, August 14th with Sal Nicolazzo and Runisa Mawani, again, noon to 1:30. So Katarina O'Brien is assistant professor in the Department of English at York University. She specializes in the literature and culture of the global 18th century. She's working on a book tentatively titled Georgic Dispossession, Poetry Across the Long 18th Century, which traces the ways that Georgic poetry has been used to justify ongoing histories of settler colonialism and racial capitalism. It also tells an alternate history of the mode by engaging the work of Black, Indigenous, and anti-colonial writers of the period who refused to define land as capital. She's also planning a second book on the Trans-Pacific 18th century with a particular focus on Tagalog poetry and the Manila-Acapulco galleon trade. Her publications include articles in 18th century fiction, novel, and a forthcoming piece in PMLA. Thanks so much for joining us and agreeing to speak.
Thank you so much, Simon, and thank you everyone for being here. I'm looking forward to talking about Stephanie's book. Stephanie DeGooyer's important new book ends by considering the too familiar context of hardening borders, the xenophobia and racism of contemporary immigration laws, and the often disturbing uses to which the fiction of naturalization has been put in the present day. Both ending and beginning Before Borders with Hannah Arendt's image of an explosion, the dramatic shift in immigration law that allowed for mass statelessness at the beginning of the First World War, DeGooyer pauses over the dangerous effects of an understanding of nationality as a fiction or manufactured commodity that could be freely given, but also easily taken away. Against these current circumstances, DeGooyer recalls readers to the long 18th century, poised between the perpetual allegiance of the early modern period and increasingly calcified formations of the nation-state in the 19th century, a period when jurists, political economists, and literary writers all experimented with and thought seriously about the generative possibilities of voluntary allegiance. That history begins with a series of legal cases on property inheritance shortly after the Union of Crowns in 1603, a series of decisions which, DeGooyer explains, would form the basis of early immigration law while raising some of the thorniest questions surrounding allegiance. Examining a series of cases from 1656 to 1670 concerning the estate of Antonati Scott, John Ramsey, DeGooyer recovers a more radical understanding of naturalization in which Parliament could create new subjects in the past and the future and erase the distinction between the status of aliens and the status of natural-born subjects. In tracking the retrospective and restorative temporality of what many saw as a dangerously heretical understanding of naturalization, DeGooyer introduces a narrative quality to naturalization that becomes crucial to the book's subsequent readings, as well as to wider understandings of the novel and the law, particularly in relation to questions of time and language. The retroactive temporality becomes apparent, for instance, in DeGooyer's reading of Pamela, which positions the fictional editor and prefatory puff writers as important agents of naturalization, precisely because they've read Pamela's letters through to the end. Having read the second half of the novel, they are able to make a case for Pamela's natural authenticity even before one reads her first letter. Here, in the context of the novel, naturalization comes to mean the introduction of new subjects and a new literary mode into narrative space, and this allows the latter half of Pamela to be read onto the first. This retroactive quality of naturalization also made me think of Squire Western's words to Tom Jones at the end of the novel, after Tom's origins have been revealed. My old friend Tom, I am glad to see thee with all my heart. All past must be forgotten. I could not intend any affront to thee because I took thee for another person. Across a compelling series of revisionist readings in which aesthetics becomes a means of navigating modes of citizenship, as in a sentimental journey, or language becomes a way of entry into political communities, as in Frankenstein, DeGooyer foregrounds naturalization as a radical and generative tool of inclusion, a process whereby texts bring new subjects into being through overtly creative fictions. But in certain ways, I'd like to suggest in my brief remarks today, an even more radical set of implications develops from the language of detachment and unrootedness that underlies this history of flexible and voluntary allegiance. And my title for today is Settler Detachments. As DeGooyer makes clear, naturalization policy was intended for a relatively select and wealthy group of white and male individuals. As she puts it, the elasticity of naturalized national identity occurred across identitarian lines, with religion and then race as the key terms for what DeGooyer calls the particulars of exclusion for naturalization. With those particulars of exclusion in mind, I'd like to think a bit more about what the language of detachment and detachability might mean for shared histories of the novel, naturalization, and settler colonialism. In contrast to the effectively charged modes of national belonging and heterofuturity that Lauren Berlant and others ascribe to 20th century forms of citizenship, DeGooyer identifies in earlier forms of naturalization a dispassionately bureaucratic process that had nothing yet to do with interiority or felt belonging. Robinson Crusoe becomes the ideal example of this process as a settler opportunist who has a detachable relationship to England and also to Brazil, where he naturalizes to accumulate wealth as a planter. Someone more interested in individual profit and global trade networks than in national affiliation. For Defoe, through Robinson Crusoe, DeGooyer writes, national identity can travel and be changed as easily as a goatskin jacket. Aside from the exciting turn away from readings established since the 19th century of Crusoe as the quintessential Protestant Englishman, DeGooyer's chapter also has important implications for thinking through the fictions and vocabularies of settler colonialism and the novel. As Alice Tepunga Somerville notes in her crucial work on the relationship between indigeneity, migration, and diaspora in Once Were Pacific, citizens from settler nations like Canada, the United States, Australia, and New Zealand depend on a different logic to connect themselves to territory. Non-Indigenous claims to effective connection with particular landscapes mimic Indigenous connections with land. And yet, Tepunga Somerville continues, the mimicry is never sufficient. Although invisibilizing, nullifying, or co-opting ongoing Indigenous presence is one settler strategy, she writes, where Indigenous presence is unavoidable or incontrovertible, the concept of a nation of immigrants links citizenship to immigration instead of autochthony. Rather than New Zealanders sharing a common connection with place, they share a common experience of mobility. I would like to think more about how the historical legal architecture of naturalization outlined in Before Borders comes to evacuate such settler claims to connection, either as mimetic attachments to land or as part of the shared experience of immigration. The language of affective settler mimicry becomes rather pronounced, for instance, in the 1767 Robinsonade, The Female American, which narrates the adventures of Unca Eliza Winkfield, the daughter of an English settler and an Indigenous woman whose nation goes unnamed for the duration of the novel. Early on in the text, Unca Eliza's father, William Winkfield, whose father shares a name with the first president of the Virginia colony, Edward Moriah Winkfield, having fallen in love with her mother, Unca, expresses something like an affective attachment for the land that he has recently helped to invade. He began to look upon the country he was in as his own, Unca Eliza, the narrator of the text, explains, and now loved Unca as much as she did him, and was therefore willing to make her and her country his forever. Blending possession and belonging, Winkfield's mode of affiliation seems in several respects to be less artificial or exterior than the tokens and external signifiers that come to denote nationhood in DeGooyer's reading of Crusoe. While readers are reminded repeatedly of the great wealth that Winkfield accumulates and continually sends back to England, he expresses a different set of attachments to the plantation even after Unca has died and he and his daughter have relocated to a pleasant village near Windsor. Growing more melancholy from the distance from the country where he had left the remains of his princess, Wingfield resolves to return and improve his plantation rather for amusement, we are told, than from desire of gain. As the novel labors to separate out affective attachment from the repeated extractions of wealth that structure its plot, I'm struck by the stark contrast to someone like Crusoe, who has a tactical and opportunistic relationship to land and settlement. His attachments, DeGooyer suggests, are to structures of global capital rather than to specific nations or places. That novel's descendant, published less than 50 years later, seems interested in an alternate set of terms for nationhood and affiliation. Uncle Eliza writes of her father, Mr. William Winkfield, of whom I must relate a very extraordinary adventure, as it gave occasion to his growing more suddenly rich than he could have done by an infant plantation, and gave birth to me, and in the consequences of it, effected a more happy issue to my future adventures than could otherwise have happened. As DeGooyer argues, part of what made naturalization so threatening in its pre-19th century context was that it was non-biological. New subjects were born and made through a garishly technical procedure rather than a reproductive process. Against that history, Unca Eliza's narrative seems interested in something like the opposite effect. The language of infant plantation, echoed also in a later chapter to describe the infant state of the colony, is linked through ambiguous syntax to Unca Eliza's birth, and the image of her father, growing more suddenly rich, shifts freely between his infant plantation and infant daughter. Effectively attached to stolen land, her father's narrative seems also to be explicitly defined by the logic of heterofuturity, a more happy issue that would come to define later notions of citizenship. In many ways, Unca Eliza would seem an ideal example of the kinds of subjects who enter into the novel form through what DeGooyer describes as narrative naturalization. As a biracial woman of Indigenous descent, she helps to exemplify the novel's disengagement from classical rules determining who could be a subject of literature. But in the world of the female American, that process of inclusion comes with many costs. Having concluded a chapter by explaining that her father died of a broken heart, Unca Eliza writes, "Having paid my father every funeral honor I could, and having nothing now to attach me to this country and the bulk of my great fortune lying in England, I determined to embark for that kingdom and to conclude my days in my uncle's family." In that brief appositive phrase, having nothing now to attach me to this country, the novel manages to invisibilize, nullify, and co-opt Indigenous presence to recall Tepunga Somerville's language, while claiming to center or make space for an Indigenous subject. The language of naturalization does occur in the female American. Remarkably, in a moment when her narrative, being set in the 1630s, Unca Eliza anticipates the possibility of a future Robinson Crusoe. Expressing her confidence that events so extraordinary should attract the reader's attention, she writes that if ever they should be published in any country, I doubt not, but they will soon be naturalized throughout Europe and in different languages and in succeeding ages, be the delight of the ingenious and inquisitive, and that some future bold adventurer's imagination, lighted up by my torch, will form a fictitious story of one of his own sex, the solitary inhabitant of a desolate island. Reading this moment alongside Before Borders, I'm fascinated by this notion of Robinson Crusoe as a naturalization of the extraordinary adventures of Unca Eliza Winkfield. It performs its own version of retroactive temporality as a textual maneuver that Betty Joseph writes, performs not the replacement of the dead father as the daughter's surrogation, but a surmounting of the ancestor by rendering Defoe into a child of tradition, mothered by Unca in the previous century. It also frames naturalization as an inherently fictional device, as the 18th century editor adds in a footnote that our authoress here seems to please herself with the thoughts of the immortality of her history and to the prophecy of that of Robinson Crusoe, which is only inferior to her own as fiction is to truth. The moment might also offer something like an echo or perhaps a presaging of those opening lines of Robinson Crusoe, which DeGooyer reads as a naturalization petition. It suggests, in other words, a contemporary understanding of Defoe's text as naturalized in both the literary and legal sense of that term. I've lingered over the female American because I think it helps speak to some of the complexity and implications of Before Borders. Decidedly alienated from her territory in contrast to her father's saturated affects and settler mimicry, Unca Eliza is, in light of DeGooyer's compelling reading, in some ways a more resonant female Crusoe than critics have tended to assume. She holds a detachable relationship to her nation, here a blurred amalgam of indigeneity under the sign of American, and her allegiances also take the form of external signifiers. As Mary Helen McMurran has demonstrated in her work on the non-realism of the novel, the image of Unca Eliza, adorned with strings of diamonds and a bow and arrow over her shoulder, borrows most directly from the fanciful female allegorical figures of America found in contemporary European art. Among those signifiers, I would add the depiction of Unca Eliza's racialized body, the repeated attention to her tawny or uncommon complexion, included alongside those generalized signs of indigeneity. That repeated shift from land to race masks the territoriality of conquest, to quote Jody Bird, by assigning colonization to the racialized body, which is then policed in its degrees from whiteness. Under this paradigm, Bird continues, American Indian national assertions of sovereignty, self-determination, and land rights disappear into U.S. territoriality as indigenous identity becomes a racial identity, and citizens of colonized indigenous nations become internal ethnic minorities within the colonizing nation state. As DeGooyer demonstrates in her section on the Wanderer, race emerges from the late 18th century and early 19th centuries as patently unnaturalizable. In the female American, on the other hand, race becomes a marker of inclusion and difference, as well as detachability. Unca Eliza may be naturalized into narrative space, but she is also detached from her rightful territory. In that respect, among the many important contributions of DeGooyer's work seems to me the tacit reminder that those subjects targeted by naturalization, those free white persons of good character specified by the 1790 U.S. Naturalization Act, for instance, were brought into a structure of invasion through an inherently fictional, economically opportunistic, and openly artificial process. Through its recurrent language of native soil and blood and natural-born subjects, including its revision or denouncement or expansion of that language, the legal history of naturalization also carries across the Atlantic another set of violent fictions. What Jody Bird describes as a series of internal contradictions where human rights, equal rights, and recognitions are predicated on the very systems that propagate and maintain the dispossession of indigenous peoples for the common good of the world. A painful irony of this history is that answers to the violence of hardening borders often rely on legal vocabularies that find flexible subject formation in the language of settler colonialism. In response to DeGooyer's final call in Before Borders to think anew the conditions from which subjects are born and made, perhaps readers might also begin to think against that irony as well, or to think differently about the fictions in which subjects are made and included. Thank you.
Thank you. So next up is Nicole Wright, Associate Professor of English at the University of Colorado at Boulder. Her research examines personhood and shifting conceptions of justice and representation in British literature and culture over the late 18th and early 19th centuries. In addition to the development theories of the novel, her interests include several topics that may be placed under the general heading of history of ideas as reflected in literature, encompassing the history of science, history of law, and changing theories of affect and emotion, along with African American fiction and poetry. These interests reflect her focus on witnessing, advocacy, and distanced representation, whether in the context of laboratory science, legal testimony, or minority self-assertion within mainstream culture. Her book, Defending Privilege, Wright, Status, and Legal Peril in the British Novel, was published by Hopkins in 2020, and her current work examines ultra-conservative uses of 18th and 19th century fiction, especially Austen, as a means of affirming their political agenda. Thank you so much, Nicole.
Thank you, Simon, for that introduction. So my title is Stephanie DeGooyer's Before Borders, Recasting Critical Genealogies. Although focused on the 18th century, Stephanie DeGooyer's Before Borders is clearly relevant to our own time. DeGooyer's chosen theme of naturalization is key to some of the most consequential recent issues in domestic and world affairs. First, political and legal grandstanding over what some partisans mischaracterize as the open United States-Mexico border, and the attendant prospect of the naturalization of Latino immigrants and, more recently, Asian immigrants entering there. Second, the Russia-Ukraine war and the imposition of citizenship on inhabitants of occupied territories. And third, the Israel-Palestine conflict, both the renewed debates regarding Israeli government officials' claims that Palestinians have avenues to naturalization and citizenship, and opposing characterizations of Israelis as indigenous and colonizers. The latter label connects to DeGooyer's examination in Chapter 3 of portrayals of Robinson Crusoe as a colonizer. DeGooyer doesn't settle for restating her claims. She develops them and offers still more complex and audacious elaborations as the chapters continue. There is a correspondence between the book's argument and its intervention in critical debates. DeGooyer aims to disrupt conventional accounts of the development of the novel and the history of ideas, and in doing so, challenges a number of figures in the line of succession of prominent critics and their schools. In novel studies, not only founding father, and since his heyday, target for critical takedowns, Ian Watt, but also Michael McKeon, Nancy Armstrong, Franco Moretti. In cultural studies, Benedict Anderson, Hannah Arendt, Lauren Berlant, Lynn Hunt, Edward Said, and many more. Just as protagonists in the novels DeGooyer surveys leave their roots behind to forge new identities, renunciation of prior ties may be generative and salutary for the field of novel studies. Some of these challenges resonated with me as useful correctives to aspects of influential accounts that didn't sit right when I first encountered them. Here are some of DeGooyer's key claims and reframings. In our era, naturalization serves elites and stirs up national sentiment, enhancing the electoral chances of political parties catering to these forces. DeGooyer seeks instead to remind readers of a more flexible, as she puts it, history of naturalization that has the potential to empower a broader range of people. Although naturalization evolves throughout history, too many critical accounts center 19th century paradigms of key concepts, including nation and naturalization, according to DeGooyer. She finds that 18th century conceptualizations of naturalization were not more progressive than those of our own time, so much as boldly based on ideas contrary to traditionalist notions of allegiance and blood and soil. She also examines how 18th century liberal conceptions of naturalization in Britain are not premised on assimilation or interiority, but instead involved externalized, often strategic affiliations that were subject to change. Naturalized affiliation is imparted through metonymy and the brandishing of tokens. More broadly, DeGooyer makes a case for rehabilitating naturalization as a critical concept, including but also beyond implications for theories of law, immigration, and nation. Building on echoes of Ricoeur and others on the hermeneutics of suspicion, she questions aspersions cast on artificiality and instead sees making natural as a commendable means of making possible new bases of affiliation. She proposes an alternative to casting naturalization as deception, discerning its liberatory creativity. DeGooyer's terms include paranationality, first introduced in the introduction, and narrative naturalization, which she applies in the Frankenstein chapter. Her book is generative. Her ideas are applicable within 18th century studies, but also well beyond. Here is a sampling of possible avenues for future research. First, a question of form. Early in the book, DeGooyer considers verse that tended to more reductively cast naturalization than novels did. The next step could be to widen the picture. In his monograph on canon formation, Alan Golden remarks on the critical neglect of poetry in favor of prose forms, usually fiction, that have a superficially more direct connection to social and historical reality. His observation reflects inversion of the former order of things. Traditionally, poetry was seen as more elevated and thus more worthy of study than prose literature. In addition, even in the wake of the 1737 chilling effect of the Licensing Act on theater, drama seems a ready supply of the kind of flat identities DeGooyer observes. I'm thinking of revivals of Shakespeare in the 18th century and the rethinking of Shylock that turns from early modern aversion into something like admiration, as documented in Emily Hodgson Anderson's Celebrity Shylock. What would a Moretti/Jockers style distant reading of naturalization beyond prose fiction reveal? For some of the novels in Before Borders, the most pronounced engagement with questions of naturalization occur on the periphery or at internal borders, the beginning of a novel, the beginning of a chapter, rather than in the main text or plot line. As DeGooyer points out, Robinson Crusoe's engagement with naturalization is centered in the first paragraph, but recedes into the background of his time on the island. Naturalization is prominently considered in the first lines of a sentimental journey, less so in some of the episodes that follow. Similarly, the interplay between the frame narrative and the creature's speech in Frankenstein. How are encounters involving questions of naturalization energized by their marginal location in novel structure? Compare the centrality of questions of naturalization in the main plots of Edgeworth's novel Harrington, which DeGooyer finds unsatisfying in comparison to Shelley's, and Sterne's innovative treatment of naturalization concerns. So I'm thinking about the positionality of these treatments. So I'm also considering here a pedagogical application. In addition to DeGooyer's response to Stephen Best, Sharon Marcus, and others, I'd add Lisa Ruddick's When Nothing is Cool, which explores what Ruddick terms the deadening effect the hermeneutics of suspicion have on the academy and its teachings. How can DeGooyer's approach change the way we help students to read character and belonging and make it relevant to them? So to turn to legal questions. Calvin's case is a watershed episode in the legal history of the era, and there's extensive research on the extent to which authors were conversant with Locke's theory, not including the unpublished manuscript referenced by DeGooyer. To what extent did authors engage with the fascinating Ramsey cases by comparison? Given that in the early modern period, jurists and lawyers often dabbled in letters, did they comment in their creative writings on these concerns? How can narrative and cultural studies take up DeGooyer's suggestion to build on Lisa Lowe's work and examine the relationship between law and literature in terms of intimacies rather than direct causality? Next, how can we develop a more comprehensive account of the extent to which naturalization protocol in European nations beyond that of revolutionary France were referenced in naturalization debates in Britain? One model for a project of this scope, the tracing of the origins and peregrinations of rights and its associated terms in the architecture of concepts, the historical formation of human rights, which came out in 2013. I was also wondering whether other prominent authors or other major thinkers of the era remark on protocol beyond Britain for entry in their travel correspondence in ways comparable to Mary Shelley's commentary on Geneva's strict laws. This question connects to Blackstone's commentaries and others' attempts to rationalize and naturalize the laws of England, and also relates to contrasts drawn between common law and civil law. So, branching out even further, can still more radical, inclusive, or forward-thinking ideas of naturalization or other concepts of belonging be found in global historical contexts beyond the West? Given DeGooyer's persuasive objections to criticism that retroactively imposes reproductive analogies on 18th century naturalization discourse, are there more evidence-based links between emerging concepts of naturalization and the discourse of natural history, which is a nonfiction genre not examined at length in Before Borders in the period? So thinking both globally and in terms of intimacies or parallels with other related fields and subject areas. So something else to consider here, race is not a prominent concern in Before Borders. It is treated primarily in the Burney section of Chapter 4. There is much more to say, however, regarding the intertwined histories of modern racialization and 18th century liberal notions of naturalization, which have similar chronological origin points. Examining these histories in tandem would be illuminating. A starting point could be Ramesh Malapati's exploration in Spectacular Suffering of enslaved people's experiences of what he calls affiliation and disaffiliation, as reflected in the writings of early Black Atlantic authors and elsewhere. DeGooyer's analysis, including both in her second chapter on keywords of naturalization and her case studies, has bearing on emerging discourse responding to incredulity regarding how deception can work despite blatant artifice and falsehood. Confer, for example, Amnoi's 2020 monograph, Theory of the Gimmick, which explores how gimmicks work despite audiences' awareness that they are being manipulated. So you can see clear parallels to how naturalization and flatness and detachable affiliations work in DeGooyer's treatment. DeGooyer points to the novelty of legal mechanisms of forced denaturalization. What about expanding the range of what might be considered precedent? What might incidents of what could be considered akin to denaturalization or naturalization under duress have in common with current practices of wealthy nations? Consider, as a point of contrast, 18th and early 19th century precursors to post-1848 captivity narratives, in which abducted settlers were said to be absorbed into tribes. Did these narrative representations differ from or resemble the discourse of liberal conceptions of naturalization? See, for example, work by Elise Marianne-Strass and Astrid Haas, and they explore connections between native bondage, African-American identity, and captivity narratives. DeGooyer's study considers various bases for subjecthood and naturalization, including allegiance from birth, wealth, and original shared human identity, invoked in Charles Grandison, which is examined in Chapter 4 of the book. To what extent are personal virtue and responsibility invoked as suitable criteria for naturalization in the law and literature of the long 18th century? And here one could consider, for example, John Tanner's case for naturalizing indigenous peoples in his 1830 narrative. So a couple more points of possible discussion or investigation. Connecting to the argument for narrative naturalization, DeGooyer's term, in the analysis in Chapter 5 of the representation of Frankenstein's creature's speech, ChatGPT's automated compositions have been disparaged as blandification in the service of the interest of billionaire overlords. Yet AI is also said to aid the self-expression of English language learners, disabled people, and other types of speakers. In terms of establishing shared community affiliations for society's outsiders, what are some additional potential advantages and drawbacks of AI's homogenization of narrative voice or emulation of normative speech? And finally, how do DeGooyer's readings indicate the way to continue unsettling conventional wisdom in studies of later periods beyond the 19th century? Regarding assertions of consensus that nation of origin is the rightful ground of shared affiliation. And here we could turn to, for example, Janice Ho's chapter on Forster in Nation and Citizenship in 20th Century Britain, which astutely reevaluates criteria for shared belonging. So here's to Stephanie, and I'm looking forward to the discussion. Thank you.
Thank you, Nicole. So our last speaker, our respondent, Stephanie DeGooyer, author of the book under discussion today, is newly tenured as associate professor and Frank Borden and Barbara Lassiter Haynes Fellow in the Department of English at UNC. Her work examines intersections between law and literature with interests in immigration, global migration, human rights, from historical and contemporary perspectives. She is co-author of The Right to Have Rights, published by Verso in 2018, co-editor of the forthcoming Routledge companion to the novel. She's published in The Nation, Guardian, Dissent, Boston Review, Lapham's Quarterly, Humanity, Los Angeles Review of Books, and Public Books. And in addition to the book we're discussing today, she has 2 book projects underway. The first is Asylum Nation, Refugees, and the Founding of America, which traces the colonial era history of legal concepts such as asylum in British common law and early American legal and literary history. The second is a book on the history and social and political function of unidentified bodily remains. Thank you so much for joining us, Stephanie.
Thank you. Thank you, Simon, first of all, for, as ever, being an incredible organizer of people and ideas. And thank you to Katarina and Nicole for agreeing to do this today. I'll have a little bit to say in a few minutes about your remarks, but just it's a deep privilege to be read this seriously, carefully, and with such new fodder for thinking. I think that's wonderful for me to see kind of, as Mary Shelley would say, this hideous progeny go forth and prosper in other ways with other people. So thank you. I sat alone with this book for a long time, and in it, I was trying to carve out a new way of seeing nationality or national identity. Well, that's a different word, but nationality, we can say, in the 17th and 18th centuries. And I really wanted to defamiliarize our understanding of this period from the paradigms we inherited from the 19th century, which have been so dominant. And a lot of this project required much archival research, new readings of books that we've already read so much and so often. At times it was pretty lonely. I didn't have a lot of companions working on the same topic. So again, just to be here and hear this is just wonderful for me. And I'm grateful for the conversation that I'm able to have, hopefully with a lot of you, but especially with Katarina and Nicole. I think I'll start out by, before I address the remarks from Katarina and Nicole, I'll just give, for the people here who haven't read the book, just a little synopsis of like why I wrote it, and the 2 reasons I did. One was a legal reason, one was a literary reason. I thought that may be helpful. The first reason I undertook the project was for the sake of a legal history. I've been working and writing about immigration for quite some time now, and most of the work I've read, very, very valuable work, concerns the history of immigration in the 19th century, the rise of race-based and restrictive immigration policies, for example. And this book was guided by a very different question, not when did it become possible to take nationality away or to restrict entry, but when did it become possible for somebody to actually change a nationality? And that ends up being a very complex question. When and how did it become possible for a newcomer to be legally integrated into a community, and in that community when they weren't born to the sovereign of that community? So if much of immigration history has been interested in restriction, I wanted to think about the moment when nationality became something that could be transferred or given, we could say. And so this naturally led me to the history of naturalization. I wanted to investigate the history. First came to me with the other book I wrote on Hannah Arendt, where she made this throwaway remark about refugees during the religious wars of the 17th century being happier because naturalization was easier for them than it would ever be for anybody in the 20th century. And that remark made me ask, well, why was it happier? And she never answered that question. And I couldn't find much other work. So that's what I undertook to sort of answer for myself, firstly, and then for the book at large. And what I discovered is that debates about naturalization, about who could be a subject of a kingdom, it was these debates that produced the earliest immigration laws in England and in common law. And that is to say that debate and concern about naturalization prompted the earliest attempt to codify a distinction between aliens and subjects. It's from this history that that very distinction emerges. So it forges, more importantly, a radical shift away from the traditional understanding of allegiance as vested in the birth to a certain sovereign and what is known as perpetual allegiance, to what I think of as a new contractual mode of nationality. One that's not interested in how you feel about the nation, as we may think about naturalization today, culturalization or felt belonging, but to a kind of very procedural legal notion of nationality. And the most interesting thing about all of this new volitional understanding of allegiance is that it occupies so many people in the period. There's jurists, philosophers like John Locke, many prose fiction writers, Daniel Defoe, Francis Burney, Mary Shelley, and so many others. So it was very widely happening in the period, which was surprising and important for me. And the second reason I wrote the book is because as a trained literary scholar, I've grown up with these accounts of the novel as originally an instrument of nationalism, and colonialism. The novel as a tool for organizing the interests of the nation state. Nicole mentioned some of the names, but we have Edward Said, Franco Moretti, Benedict Anderson, all have had arguments to this effect. But when I was drawing back the curtain on early immigration law, I noticed how many so-called early English novels were concerned with what I come to call paranationality. They're concerned with how identity changes as it migrates and with contractual understandings of national allegiance. Understandings that see nationality as something that can be easily exchanged or expunged. And for example, the most obvious example of this in the book is Robinson Crusoe, which is often called upon to exemplify a certain English nationalism, but it's actually way more interested and invested in the intricacies of global trade than national colonialism per se. So those were the two kind of big law and literature reasons. But now let me get to the actual response, because as I said, these remarks were so substantive and so interesting and so generative. So I've composed a few thoughts that I hope can be something of a response. I'll begin with Katarina and what she articulates as, quote, an even more radical set of implications from the language of detachment and unrootedness that she locates in the history of naturalization outlined by my book. Katarina frames an incredibly interesting and excellent question, and that is the question, what does the language of detachment or detachability mean for shared histories of the novel, Naturalization, which I sort of cover in the book, but also settler colonialism? And I think that last part is key. My first response to this question is, of course, naturalization is more than a language. It's a law, but of course, law is also a language. As a law, naturalization has historically been aligned with the interests of the state rather than the individual, especially in the 20th century. It has been, for better or worse, for much of the history we've known, a way to homogenize a foreigner to the state, to make them conform to its interests. In the early 18th century, however, naturalization was constructed as a way for an individual to become like a subject for the purposes of property acquisition. So it's important to note that essentially naturalization was a gimmick. And yes, I mean that in every sense of the way meant by Sian Nai, though I don't engage her 21st century theory in the book. Naturalization was a gimmick designed to grant an individual rights that were not meant to accrue to him. Mostly always it was a male. So naturalization is not a way to enforce belonging or to control it or govern it, as we could say it is now. It's a legal fiction designed to circumvent belonging. But as Katarina shows in a brilliant reading of The Female American, a novel I had so hoped to be able to include in the book, but I couldn't fit it in under the parameters of the way it was written. In that novel, the fictions and vocabularies of settler colonialism also employ an insufficient mimicry of connection to the land. And I really, really like this reading. And I really like this avenue of thinking. First, I would point out that the early legal fictions of naturalization were not really about mimicry of connection to land or to nativeness to land itself. The legal fictions of naturalization were about, as I mentioned, the relationship to the sovereign. Nobody undergoing naturalization was asked to feign a relationship of belonging to a place. The fiction was instead, in its earliest offerings, was a way to erase a past relationship or allegiance to another king. Subjecthood, as the famous Calvin's case would lay clear, was about this relationship to the sovereign rather than to the soil on which you were born. So that's the kind of legal history here. But what Katarina has opened for us so brilliantly is a distinction that I began to think of myself when I was writing this project or ending it. And ultimately, it has come sort of to lead into the basis for my next project, as well as a few articles I've recently written on early America. What Katarina calls the language of effective settler mimicry is everywhere, I would say, on display in the battle between the Americans and the British over the right of naturalization. As many of you will recall, one of the major grievances in the Declaration of Independence concerns the right to control naturalization. The Americans want to separate from the British, but the British insist upon their right of allegiance, because allegiance cannot be broken. At no time was this clearer than during the Napoleonic Wars, when the British Royal Navy impressed thousands of American sailors into the service of British vessels. So bands of British soldiers known as press gangs would barge into seaport taverns and dock to merchant ships and search for American soldiers and force them into military service on behalf of the British Crown. And the argument that the British made was that they had the right to conscript Americans against the will under the ancient common law principle of perpetual allegiance, which held that those who were born under the British Crown owed allegiance to Britain in perpetuity. And of course, they're doing this after independence. And so that's how long they held on to this idea. America, this is a long way of saying, represented at the time a new kind of settler colonial relationship. Americans, as they argued, became Americans not by being born subjects of a sovereign, but by making themselves Americans, by, quote, what Katarina calls blending possession and belonging. And just a side note, I've been reading a lot of de Crèvecoeur's notes from an American farmer, and you can see a lot of this blending of possession and belonging on display in that book pretty substantially. So I think that the colonies do represent a new and very important chapter in naturalization's history, which is why I'm driven to work on that intersection now. And as I said to Katarina before, I really hope that you publish this work on a female American, because I really do want to be able to cite it and work with it. I think it's really important, and it's a blind spot in my own book for certain. Okay, so now I'll turn to Nicole's remarks. Your remarks and summary of my book left me with the feeling of watching someone else sum up my work better than I ever could. I appreciated deeply how you capture all the nuances of the project. There's so much to respond to in your remarks, but I'll keep it brief and I'll mention a few main things that struck me. One of the things I loved about Nicole's remarks is how she grasps my interest in the project of national abandonment through naturalization, to the study of the novel itself. I really love how you say that the renunciation of prior ties may also be generative and salutary for the field of novel studies itself. I think that's very clever and very accurate, at least as far as my work is concerned. This was something I certainly came to encounter as I worked on the project, as the usual histories of the novel that I read in graduate school and sometimes teach to graduate students today, they seemed not to work. And more worryingly, they were falling flat in the face of so much of the history I was uncovering. And that led me to sort of in the coda remark on how I think so many of us literary scholars of the period do need to know more about legal history. It's a blind spot for so many of us. Just a little side note here that your remarks about drama and its flat characters is so fascinating. I've had people who work on drama approach me about naturalization. And for me, it's complicated because so much of drama is still beholden to classical models of who can be a subject or a character, but at the same time is sort of also participating in the kind of flattening of character. So I think that that's a really interesting intersection to think about, as do I think about what you were saying about natural history, but I'll leave this for the comments and just move on to your question about the Ramsey cases. It's not at all clear from anything I've looked at that the novelists knew anything about those legal cases directly. I mean, they're pretty obscure. At most, if they knew anything about naturalization, novelists such as Smollett and Edgeworth and Defoe, they knew about the Naturalization Acts, which were quite public, especially in the middle of the century with the Jewish Naturalization Acts. But yes, the point about Lisa Lowe's intimacies is really spot on. I use the word contiguity from Hume, David Hume, to suggest ways that law and literature are intimate without being causal, so that they work together to frame ideas without being directly in conversation. Your big question, I think, from your remarks that I really wanted to talk more about is the question about whether there's more radical or inclusive ways of framing naturalization and whether these more radical ways can be found outside Britain. And the answer is definitely yes. One example I've been writing about and researching recently for my new project is about the Palatine refugees, the German Palatine refugees who come to America, and the clan mothers of the Haudenosaunee League. For the first decades of the 18th century, the Palatines and the Mohawk people lived together in what we could call a mutually beneficial arrangement as allies against land investors from Albany and against the colonial powers which sought to make fraudulent claims to the land. So in this early period, the Palatine refugees showed little loyalty to the British crown. They declared in a letter to the governor of New France their wish to remain neutral during the 7 Years' War. And they described themselves notably, quote, as a nation which is neither French nor English nor Indian. Yet, predictably, maybe from the vantage of history, the Palatines do eventually come to work with the colonial government. They begin to apply for licenses to purchase Indian land. And from this point forward, the Palatines, former refugees who remained in the valley, would outnumber the indigenous persons. And 40 years later, in 1759, in a letter to Sir William Johnson, the superintendent of Northern Indian Affairs, the clan mothers would express their disappointment with the Palatines who had come to colonize their homeland. The former refugees, the mothers wrote, quote, had grown so rich that they not only refuse to pay us for our land, but impose on us in everything we have to do with them. As Nicole mentions in her paper, in her discussion of captivity narratives in John Tanner, there is substantial evidence, there's literary and historical evidence of alternative modes of naturalization among indigenous peoples. There are many written accounts, for example, of settlers sending their sons to live among the Mohawk people. The Palatines did that often. But yes, these alternative modes would eventually be exploited by settlers. And it's at this juncture that I'm looking to sort of look at what alternative modes of asylum look like in the New World. And we'll be certainly reading this archive more substantially. It's very fascinating. Okay, just to end, I think often about your remarks about AI and whether it offers something like narrative naturalization I explore in Frankenstein. This is so fascinating. And it's something I wish I could have engaged, or I think it's worth teaching with my students, this idea when I teach Frankenstein quite often. But suffice to say, I'm aware that there are, as you say, drawbacks to having your voice emulated by another, just as there can be empowering effects to that. If you have ALS or other disabilities, it just depends. But what you're alighting on, I think, is that there's a double history or a double effect of naturalization. And my book sort of begins by saying we've spent a lot of time thinking about the drawbacks of naturalization, its coercive effects, but can we begin to see its benefits historically? But as I'm always clear-eyed about, is that nothing is ever fully a benefit, right? The longer history of naturalization is that once you can take nationality and remove it and claim it elsewhere, you're opening up the idea that you can have it removed from you by someone else as well. So there's always been a kind of double-edged history to the procedure in many of its formations. And just I'll end by saying that I love this idea of using naturalization to reread character. I'm not sure how I would go about it, but I would love to hear how you would, because I think that's really tremendously fascinating. Okay, I'll stop there, and hopefully we can engage, or Simon, you can tell me what we do.
Yeah, thanks a ton. That was terrific. Lots of wonderful questions. So yeah, we've got plenty of time for discussion. Just use the raise hand function. So I might just ask a quick question to get started. This is to do with the contiguity and intimacy point that Nicole raised and that you commented on, Stephanie. So a reason why I find this compelling, and I'd love to hear more about it from both of you, anyone in the audience who's on a law faculty will know that whenever we try to run sort of legal historical arguments, especially legal historical cultural arguments, there's a very particular notion about influence and causation that legal historians, that is, people who study the history of cases and who teach on law faculties, they've got a very particular idea of. I think it's probably inherited from what they know about proof standards in court. So they think that any legal historical claim must be subject to a proof standard equivalent to some that you would articulate in court. And obviously, what I find attractive about the idea of this intimacy contiguity argument or approach is that, if I understand correctly, not only does it not pursue that notion of causation, but it puts it to the side as simply not a helpful way of trying to understand influence and causation. So I was wondering if I could just invite both of you to say a little bit more about it, in the spirit of sort of fostering the kind of interdisciplinary study that view of causation might help to foster.
So I have some, do you want to go first, Stephanie?
No, I was going to say you should go first.
So I was thinking very concretely about this question, and we can consider intimacies and contiguities kind of more metaphorically or more kind of concretely. And a really good text here that we could consider is James Thomas Stevens's Tokenish. So he's an Indigenous poet who's writing, at the end of the 20th century, beginning of the 21st. And his poem is all about borders, and he's using he describes the border between his own Indigenous body and that of his white male lover. And he thinks about how we can naturalize and how we can blend and traverse those borders, both in terms of the borders between skin, but also in terms of he sets his poem in the context of German thought and theories about belonging. So if we think, both concretely and metaphorically, but also in terms of how these contiguities can be made vivid to us in terms of imagery. I think that's a text that right away to me really approaches and speaks to your question.
Wow. I'm going to have to look that poem up, Nicole, because it's beautiful and it also seems something great to teach with. So thank you. When I was writing the book in the intro and to a certain extent throughout the book, and especially in the coda, I try and challenge both literary and legal scholars to sort of get to think before their borders in a way. In one way, Simon, and you know a lot about this, we've spent some time speaking, is legal scholars will look at a case for certain things. Like the Ramsey cases are my big example. They'll look for the ruling, well, not so much the precedent because it's a little earlier for that, but they'll look to see what the judges decided, what Koch had to say about it or whatever, and then they'll move on. Whereas I spent a lot of time looking at the so-called dicta of how these justices tried to come up with metaphors to explain what it is they were licensing to certain effect. And I think that's one way that I really like to think about law and literature working side by side. In other words, what is said in these sort of reports isn't necessarily have any binding effect or bearing, but it's incredibly interesting. And then you can then see it echoed in the novels, which again, at no point am I ever aware that Defoe was reading the intimate legal reports of these cases, although he was definitely aware about naturalization. He wrote quite a bit about the Palatine refugees. But I liked how Hume had this notion that things can be not touching, but talking about the same things. And one of the things that the novels are really good at is imaginative scenarios that go way beyond the one sentences that a justice may use to sort of foresee a hazard or look at something. The novels can kind of go into zones that the law can't. But at no point do I want to say that any of this was causal. But for me, that's not even the interesting part. It's how did they understand this new form of nationality that was emerging? And I don't think it's a question that can be limited to the law. As we didn't talk a lot about him today, but John Locke was totally writing about this in the two treaties of government. So it's pretty widespread and something in the orbit of intellectual history, really. I'm not sure if that answers Simon, but that's how I was doing away with the idea that we should only be strictly causal and determined by standards and rulings. It's just not as interesting for what I'm doing in a period where archives are all over the place and boundaries are not as precise.
Thanks. No, I think that's a wonderful answer. And I love your framing it as a way of doing intellectual history because the term is used to mean different things, but we rarely hear about people speaking about legal intellectual history. And to think of history of law in relation to intellectual history, I think I would like to think requires doing the kind of thing that you're doing. So I think that's terrific. Thanks so much. Patrick, please.
Yeah, thank y'all so much. My brain is like, which is very exciting. I thank you, Nicole, for bringing alternative forms of literature. So my background, my PhD is actually theater history, theory, and literature. So I've got drama in performance is like I have a background in acting. I've taught acting. So what I want to bring up is one example of this. There's a play called Metamora, which was written and produced in 1829, huge hit throughout the 1830s in America at the time of the Indian Exclusion Act. This play was performed by the preeminent American tragedian named Edwin Forrest. Edwin Forrest was presented himself as a muscular American reaction to effete British artificial acting. He was claiming a spade of being more natural. He is performing this tragedy as Metamora, who was a theoretically historical, it's very fuzzy, Indian chief in the 17th century during the founding of the early American colonies. It's a classical imitative tragedy, but what it is doing is Forrest was very much about positing a particular kind of aggressive American identity that now we would practically call nativist, but doing so by putting on the skin of a Native American character while foregrounding his utter and complete whiteness, because it was that whiteness of early American identity. And so I don't really have thoughts about that particularly, other than I think that's an interesting site for some of this negotiation. And I think the way in which drama and performance plays into this notion of like naturalizing character, I think has some interesting vision that drama on the page doesn't always have. So it's really kind of exciting to think about some of that. But I think there's a lot of examples, if you are looking at plays, that really do this. The thing is, they're not good plays. Like Metamora is not a good play. It is aggressively mediocre. And I'm a big proponent of mediocre plays because they actually teach us a lot more than like great plays do about what's going on and give us a different site for reading. So if you are interested in looking for like theoretical or performative examples in like a work on the novel as a side note, one thing to look at is the great plays aren't really going to help you, but the lesser plays often will. My dissertation is about the French Revolution, which produced no great plays, but produced a lot of plays that tell us a lot of things. So I'll sort of pause there, but thank you for something really, really exciting, giving me a lot to think about and possibly a paper I may need to write. So thank y'all.
I want to invite Nicole also to speak because I think your remarks were kind of sounding off on natural history and ideas of the natural, and you mentioned drama. I'll repeat my own, why don't I talk about drama? Not because there's no examples. I actually just attended a fascinating talk in London about opera. But the reason the novel is the case study for me for this book is because it was undoing all kinds of rules about art. And it's the best example. And you have all these people writing about, it's abortive, it's all these things because it has nothing to determine how it should work. And that kind of, that's interesting to me that concurrently, there's this law emerging, and it's no surprise to me that so many novels are exploring what it means to leave England or to arrive in England. But that doesn't discount or mean that there isn't like other genres working on this. And so that is another avenue for exploration. And I think this play you mentioned, you said it's an American play?
Yes, it's an American play by John Augustus Stone called Metamora.
Yeah. So that I don't have fully emerged thoughts here, and maybe I'll let Nicole talk, or indeed Katarina, because but to me, this is something what's fascinating about the American context that my book sort of leaves at the end, and the reason I'm interested in it now, because they're trying to rethink new ways of belonging outside of this notion of perpetual allegiance. So I will definitely read this play. I'll tell you that much. And probably I'll get in touch with you to talk more about it because it sounds really interesting. But do either of you want to comment on this? I think maybe you all have thoughts too, probably.
I actually would respond with a quote from Before Borders, because there's a moment where you do talk about this kind of legal history in terms of theater and performance in your introduction, where you're talking about persona ficta. So you say, in effect, through naturalization, the natural flesh and blood individual was replaced with a legal persona or persona ficta. In Latin, persona originally referred to a theatrical mask, and this sense survives in the idea of a legal persona, an artificially designed identity meant to obscure personal and material facts of life. So in that kind of etymological history of persona linked to theatrical mask, I think there's something about like the artificiality of persona, and maybe this also speaks to like not just theater, but the question of character and naturalization that I find so fascinating in the history you lay out. And in that sense, it might lend itself to thinking about drama and this crazy play. So yeah.
Wow, I forgot about that because I worked on persona ficta. I spent so much time trying to get that part right. But yeah, the essential idea is that nobody cares about depth or interiority at all, which is something that I think scholars of the period often forget, especially when they're studying the novel. We get so obsessed with the development of interiority that we forget that one of the things that naturalization is doing, it says, well, we all know this is fake, but it works, so let's move on, and I guess in the context of this play that I haven't read, I mean, you mentioned that you have like a character putting on the skin of a native person.
Well, it's more that, I mean, the actor is doing that. So it's just,
Right.
yeah, right. But yeah.
But it's not supposed to be real in any way. I mean, that's what I don't know because I haven't read it. So I don't, that's why but yes, this idea of like a kind of thinly laid persona that functions in the case of naturalization merely for the sake of the law. Nobody really believes that this person is newly born, right? They all know that it's a kind of gimmick or a parliamentary trick, but it works, right? But there has to be a narrative and a story that explains why it works, even though everybody knows that it's a gimmick. So I'm going to read this play, but Nicole, did you want to mention something?
Yes, this is an example of how this could be extended, from Stephanie's discussion in her book to a whole other array of questions. And I have a couple thoughts on this. First of all, this really builds into, as you may have written about in your dissertation, discussions of posture in performance during the 18th century. So I'm thinking back to John Weaver's anatomical lectures on how performers should present themselves. Do you present yourself in this very formal, artificial way, or do you act more naturally? If we think about things like stage directions and props, and also it kind of reframes what we see as these plays that are very impoverished as compared to later drama. And we can turn that on its head and say this is more evocative of the types of discussions and questions pertaining to naturalization that that Stephanie brings up. And it also connects later to this came up during the conference presentation of this panel, but it also has been written about in some recent essays, one that appeared in the Times this year, about performance as an element of what people go through during naturalization investigations. So someone in the Times, I think it was within the last few months, wrote about how he had to brandish letters from his wife and had to make a mention of how their apartment was set up in order to perform what was needed for naturalization. So there are several connections here, but I'll leave it there.
So could I just add as a footnote to the comments that Stephanie was making that Sal Nicolazzo, who will be speaking in this series shortly, her book Vagrant Figures similarly treats legal forms and processes as not constitutive of identity and not deep. And one of the things that I think is fascinating about Sal's approach is that it doesn't suppose that we have to think about this in terms of legal fictions. That is, that there's such a thing as legal artifice that needn't be a fiction. So although legal fictions are certainly one way of facilitating exactly the effects and results that Stephanie's been describing, a lot of legal forms that have to do or that touch on personhood aren't even necessarily understood as fictional or presented by judges and lawyers in ways that make them sound fictional. But yeah, thanks to everyone. Let me just see if other thoughts, comments, questions.
I just want to put in a little plug for Sal because I love their work and I'm so glad they're going to be speaking in August. Terrific.
Yeah, I highly endorse attending that session.
Well, it sounds like we may be talked out. So I will just say thanks to our speakers. Thanks to everyone for coming. And I hope you'll make it to another session sometime soon. Take care.